Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now, take a look at this. Ripple files opposition agreement to pay $10 million in penalty to the SEC. In a filing regarding XRP remedies, the United States Securities and Exchange Commission SEC demanded a number of arguments, and Ripple disagrees with these requests and asserts that a penalty of $10 million is reasonable. Ripple has submitted a response to the motion for remedies and entry of final judgment that was submitted by the United States Securities and Exchange Commission. The company has responded to the SEC request for disgorgement in the amount of $876 million and prejudgment interest in the amount of $198 million, instead of the $876 million civil penalty that the SEC is seeking. Ripple argues that a civil penalty should not exceed $10 million that is being sought by the SEC. Close to Ripple, according to Stuart Alderoty, the case brought forth by the SEC is devoid of any allegations or findings of carelessness or fraud. Ripple Labs has submitted its opposition to the petition for remedies and entry of final judgment that was submitted by the United States Securities and Exchange Commission. In doing so, Ripple Labs has declined to pay the disgorgement amount of $876 million and the prejudgment interest amount of $198 million that was asked by the SEC. Ripple, on the other hand, has agreed to pay a maximum penalty of $10 million rather than the $876 million civil penalty that the SEC had said it should have paid. Are we getting closer to the end of the US SEV? Ripple lawsuit. Ripple expressed its disagreement with the arguments and fines that were presented by the United States Securities and Exchange Commission in its remedies-related briefing on April 22. As a result of the court's decision that Ripple had violated Section 5 of the Securities Act of 1933 by providing XRP under institutional investment contracts, the company has agreed to pay civil penalties. The following are the three arguments that Ripple presented. The Securities and Exchange Commission has not been able to prove that there is a likelihood of violations in the future, and that Ripple has recklessly disregarded the law in its institutional sales. With regard to the Govel case, disgorgement is prohibited because the SEC is unable to demonstrate that there was a monetary loss, and Ripple's legitimate business expenses can be deducted from any disgorgement. In light of the CC's feeble arguments and the fines it has handed down in other cases involving digital assets, the civil penalty should not exceed $10 million. After receiving instructions from the court, Ripple informed the court that the business has altered the manner in which it sells XRP, received licenses to sell XRP outside of the United States, and altered its contracts in order to prevent any potential problems. Ripple, on the other hand, was not in agreement with the SEC's remedial requests, which were an indication of regulatory overreach to issue an injection based on the mere possibility that Ripple would violate the laws in the future. In addition to the opposing brief that it submitted, Ripple also submitted supporting declarations and exhibits that provided evidence of the company's compliance with applicable regulations and permits to sell XRP in other jurisdictions. The SEC is scheduled to submit its rebuttal brief under seal on May 6th. As an additional point of interest, until the 20th of May, parties and third parties are required to submit letter motions and oppositions pertaining to sealing details in the filings. CC News reveal appeal. Settlement. Close to Ripple, the SEC is seeking a final judgment against Ripple to pay $876 million in disgorgement, $198 million in prejudgment interest, and $876 million in civil penalties. Stuart Alderoty addressed the SEC's flawed filing to the United States Securities and Exchange Commission. Close to Ripple, despite the fact that Stuart Alderoty maintains his confidence that Judge Torres would proceed with this last remedies phase and rule in a fair manner. He asserts that the SEC's case did not contain any charges or findings of recklessness or fraud. It is now public knowledge that we are opposed to the request made by the SEC for a penalty of $2 billion for legacy institutional sales. In a case that did not involve any charges or conclusions of recklessness or fraud, and in which Ripple ultimately prevailed on major grounds, the SEC's request is only another proof of its continued intimidation against the entire cryptocurrency industry in the United States, he stated. Apply right away. In response to the recommendation made by the SEC to levy a fine of approximately $2 billion against the company, Ripple Labs has voiced its opposition. The court should issue a civil penalty of no more than $10 million, according to Ripple Labs, for their actions. Ripple Labs submitted its opposition to the proposal made by the United States Securities and Exchange Commission to seek a judge in New York to impose a fine of roughly $2 billion against the business that is responsible for the XRP Ledger blockchain. The opposition was submitted on Monday. According to the petition, the court ought to reject the requests made by the Securities and Exchange Commission injunction for disgorgement and for prejudgment interest, and it ought to impose a civil penalty of no more than $10 million. Ripple Labs was required to pay a total of $1 billion in civil penalties, including $876 million in disgorgement, $198 million in prejudgment interest, and in a civil penalty of $876 million. According to the proposal that was submitted by the Securities and Exchange Commission, similar charges made by the SEC that the selling of XRP on exchanges and through algorithms also violated the law were dismissed by the court, despite the fact that the court had concluded that Ripple had broken federal securities laws by conducting institutional sales of that cryptocurrency. In their letter, the attorneys for Ripple stated that the remedial demands made by the SEC are another evidence of the administrative overreach that has plagued this court case. According to the agency's actions, it seemed as though it had won the case completely and demonstrated reckless behavior. Neither of these things has been accomplished. In addition, the government agency is requesting a disgorgement that is prohibited by the precedents of the Supreme Court and the Circuit Court of Appeals, as well as a separate penalty that is greater than 20 times the amount that it has recovered from any other defendant or respondent about a digital asset case. Additionally, the corporation asserted that it did not have any gains to disgorge in a line that omitted Ripple's revenue from institutional sales, income taxes that it paid, and losses that it incurred. Within the context of the XRP case, Ripple has submitted its opposition to the request for remedies and entry of final judgment that was submitted by the United States Securities and Exchange Commission. The firm that specializes in financial technology responds to the government agency's demand for over $2 billion in fines by proposing a maximum payment of only $10 million. The 186-page objection document that Ripple submitted late on Monday summarizes the company's arguments against the severe requests made by the SEC in response to a court order that found Ripple in breach of securities laws for selling XRP to institutional investors without first obtaining the necessary registration. Ripple begins by recognizing the infraction, reiterating that it acknowledges the ruling of the court, and providing specifics regarding the improvements it has made to comply with the regulations. The ruling has been officially accepted by Ripple, and the company is doing so once more now. In order to circumvent the issues that were brought to the attention of this court, it has altered the manner in which it sells XRP and altered its contracts, the paper ads. This acknowledgement is extremely important because it lays the groundwork for the company's contention that more punitive actions, such as an injunction, are not required under the circumstances.